step inside a Sydney magistrate's court. It's January 1959, and the air. Well, it isn't just thick with legal argument, you know? It's crackling. There's this real tension, the kind you'd find in a proper thriller novel.
Yeah, absolutely. And we're about to see something pretty unusual. I mean, truly shocking, really.
A barrister, right. An officer of the court supposed to uphold justice, launching this savage public attack on another lawyer.
Exactly. And not based on facts, not really. It seems it was designed purely to, well, destroy his reputation, his career even.
It wasn't advocacy as we know it. It felt more like a calculated ambush.
And the sources we're digging into today, they make it really clear this wasn't just some, personal spat.
No.
It was a massive breach, a profound breach of the ethical duties that basically hold the whole legal system together.
It's a true legal drama. And the amazing thing is it's pulled directly from these dry official court records.
Yeah, which makes it even more powerful, I think. It became this foundational cautionary tale, defining the lines, the absolute lines. No lawyer can cross if they want to stay in the profession.
Welcome to the deep dive. Today we're taking a really close look at this dramatic saga. It's all detailed in our sources. The famous case of Clyne v. NSW Bar Association from 1960.
And our mission, really, in this deep dive is to guide you through this incredible story.
Yeah, we want to introduce you to the main players, trace the really complex steps of how this litigation unfolded.
Unpack the ethical boundaries that weren't just, nudged. They were completely demolished.
Absolutely. And reveal exactly why this case is still taught today, why it's held up as this powerful, sobering warning.
Especially for anyone thinking about practicing law, particularly at the bar.
Yeah.
As a barrister.
It's got all the elements, hasn't it? Like a true crime story, scheming, high stakes, that big courtroom confrontation.
It really does. But its power, its real impact, comes from being totally grounded in the facts. The facts presented right there in the court judgments.
Yeah.
And it shows, in really vivid, sometimes uncomfortable detail, the devastating consequences. The real-world fallout, when that huge privilege of legal advocacy gets abused for improper reasons.
Okay, let's unpack this. Our story begins, maybe surprisingly, not in a courtroom.
No, not initially. It starts with a marriage collapsing into what the court itself later described quite dramatically as an orgy of litigation.
An orgy of litigation. Wow. Okay, tell us about the family involved.
Right. So we start with the Jacombe family. They came to Australia in 1954. Arrived from overseas with what the sources say was very considerable value, either money or property, quite a bit of wealth.
They were married, had a daughter.
Yes, a married couple with a child. Although, interestingly, some early sources apparently described Mrs. Jacombe as a reputed wife.
Odd detail. Does that matter much?
Not really. Not for the core ethical stuff we're looking at here. They were, for all intents and purposes, a married couple.
So they arrive, wealthy, aiming to build a new life, presumably. But,
Yeah, things went wrong pretty quickly. By 1956, the marriage was already showing signs of strain. Mrs. Jacombe even left home for a bit, but then she came back.
Okay.
But the real breaking point, the point of no return, that seems to have been in 1958, around the end of August that year.
What happened?
Mr. Jacombe was found. Well, in circumstances that strongly suggested he'd committed adultery. And the notable thing is, he never really seemed to deny it in the legal proceedings that followed.
Right. And Mrs. Jacombe's reaction?
She left their home. For good this time. That was on September 2nd, 1958.
And that's when the legal floodgates, as they say, truly opened.
Oh, absolutely. Just over 2 weeks later, September 17th, 1958, Mrs. Jacombe filed for divorce. The grounds, her husband's adultery.
But like you said, this wasn't just a straightforward divorce case.
Not even close. This is just the first drop in the bucket.
Yeah.
What came next was this explosion of legal action. The High Court Chief Justice later called it that phrase again, an orgy of litigation.
It paints quite a picture.
It does. By December 1958, so just 3 months after the divorce suit even started, the number of separate legal cases between this estranged couple had just ballooned. Somewhere between 20 and 27 distinct proceedings.
20 to 27 lawsuits between one couple, that's staggering.
It really is. And it tells you something about the sheer level of bitterness, the acrimony, and just the scale of the legal war they were waging.
And who was driving all this litigation?
Well, interestingly, the sources point out that most of these cases were actually started by Mr. Jacombe.
Oh, really? So he was the one being aggressive legally?
It seems so. He was clearly taking an aggressive stance on many different legal fronts. But For the case we're really focusing on today, the disbarment case, there were 4 key proceedings where Mrs. Jacombe was the one actively pursuing claims against them.
Okay, those are the important ones for our story.
Yes, they became the focal point later. These were the cases that Clyne's actions directly related to.
So what were those 4 core battlegrounds?
Okay, first, you had Mrs. Jacombe's divorce suit itself, based on the adultery claim.
Right.
Second, there was an equity suit. That's where she was asking the court to look into certain money she claimed was hers, separate from his funds, like an accounting.
Okay, makes sense.
Third, a suit under a specific law, Section 66G of the Conveyancing Act. That law deals with dividing up or selling property that's owned jointly.
And the property here was?
Their home, a place called Linton Manor, which was held in both their names.
Got it. And the fourth?
The fourth was an application made within the divorce case. It was for something called alimony pendente lite.
Pendente lite, while the litigation is pending.
Exactly. It's a legal term for interim spousal support. Money paid while the main divorce case is still going on to tide the spouse over.
Okay, so those are the 4 key cases that are central to what happened next.
Precisely. And here's a crucial point. In all 4 of these critical proceedings, the ones initiated by Mrs. Jacombe, she was represented by the same solicitor.
Enter Mr. Mann.
Yes. Mr. E.R. Mann from the firm E.R. Mann & Co. He was her solicitor across all these key fronts.
And we know a bit about how things were progressing, like that alimony application.
You do. The sources tell us that application for interim alimony came before the registrar in divorce, that's a court official, in late November 1958.
Okay.
Got adjourned, pushed back until February 1959. But crucially, the registrar ordered Mr. Jacombe to pay $36,600 per week in alimony and maintenance during that adjournment period. So Mrs. Jacombe was getting interim support.
Right. And what was the view of Mr. Mann, the solicitor? I mean, was he seen as maybe stirring the pot, contributing to this orgy of litigation?
No, not at all. According to the sources, they're quite explicit on this point. They state, there is nothing in the material before us to suggest that Mr. Mann had in any way acted otherwise than in the best interests of his client.
So he was just doing his job.
Exactly. He's portrayed as an experienced solicitor, diligently and properly advocating for Mrs. Jacombe, trying to protect her rights and assets in what was obviously a very complex, very messy, and rapidly escalating legal fight. He wasn't the cause of the fight. He was representing one side of it.
Okay, so you've got this incredibly litigious situation, a tangled web of lawsuits, and a solicitor just trying to do his duty by his client. That really sets the scene for Mr. Jacombe's reaction, doesn't it? And the arrival of our antagonist.
It absolutely does. Mr. Jacombe, facing this determined legal challenge from his wife and represented by a diligent solicitor like Mann, well, he's started to see Mann himself as the problem, as a formidable obstacle.
An obstacle to what, exactly?
To getting a quick, easy settlement. A settlement on his terms, Mr. Jacombe's terms. He didn't want to fight 20-something lawsuits on their merits. He wanted them gone, or at least easily compromised.
And this frustration led him to make a change to his legal team.
It did. The sources mention that in December 1958, Mr. Jacombe switched solicitors. He let go of the firm that had been acting for him up to that point, the ones who'd been instructing other barristers for him.
And brought in new ones?
Yes. From that point on, new solicitors acted for him. And crucially, they were the ones who instructed the barrister who becomes central to our story, Reuben Clyne.
Do we know who the previous lawyers were? Or the new solicitors?
No, the sources we have for this stage don't actually name them, just that there was a change, and that Clyne was brought in as counsel by the new team.
Okay, so tell us more about this Reuben Clyne, sometimes called Peter Clyne, right? What was his reputation?
Reuben Peter Clyne, yes. He'd been called to the New South Wales Bar back in the 1940s. And the sources, and legal history generally, describe him as known for fierce advocacy.
Fierce?
Yeah, he had a reputation for being unconventional, for pushing boundaries, sometimes quite dramatically in court, definitely known for a confrontational style.
So Mr. Jacombe, totally fed up, facing this determined opponent, hires Reuben Clyne, a barrister known for being aggressive, for pushing the limits. What was their main goal now?
It was stunningly simple, really. And quite desperate. Mr. Jacombe wanted to get rid of Mann.
Just get rid of him.
Yeah. He seemed to believe that if Mr. Mann could somehow be removed as Mrs. Jacombe's solicitor, she'd be left without effective representation.
Yeah.
And then the thinking went the proceedings would probably just collapse, or at least be very easily compromised.
Right.
Jacombe could dictate the terms.
So the strategy wasn't about winning the cases based on law or fact?
No, not at all. It was a direct attack aimed squarely at the opposing lawyer, Take out the lawyer, the cases disappear. That was the logic.
Had Mr. Jacombe tried anything like this before? I mean, pressuring his wife or her lawyers before Clyne came along?
He had, yes. The source points to this very remarkable letter Mr. Jacombe sent. He sent it directly to Mrs. Jacombe herself back on September 6, 1958. This was shortly after the divorce suit started, well before Clyne was involved.
And what was so remarkable about it?
Well, its content was extraordinary. He started by suggesting the divorce suit should be undefended. He framed it as a way to avoid unpleasant publicity.
Okay, it sounds reasonable on the surface.
But then came the threat. A barely veiled threat. He said he had evidence he could present at trial that would be most material in fighting her divorce claim. And even more pointedly, he said this evidence would rebut her claim for alimony and custody of their child. He was essentially saying, if you don't agree to my terms, I can stop your divorce, deny you money, and to potentially impact your relationship with our daughter.
Wow. Using the child's welfare as leverage. That's grim.
Exactly. He then offered what he called a dignified approach and an amicable settlement, but only if she agreed to his terms on alimony and custody.
So, a clear attempt at intimidation, using the threat of public embarrassment, possibly harming the child's situation as a bargaining chip.
Precisely. And the court later picked up on this specifically. They noted the worst feature of the letter was him offering to not bring up matters potentially affecting the child's welfare, simply to get the financial and custody deal he wanted. It was blatant leverage.
Did it work? Did she or Mann respond?
No. The sources say no reply was ever received. Not from Mrs. Jacombe, not from Mr. Mann. It seems Mr. Mann, quite understandably, wasn't willing to negotiate based on that kind of extraordinary, threatening letter.
So Jacombe's direct pressure tactic failed.
Okay, so the direct approach fails. Now he turns to Clyne, the boundary pusher. What plan did Clyne and Jacombe cook up to get rid of Mann?
Well, Clyne apparently said later that he considered 3 possible ways to attack Mr. Mann based on what Jacombe told him. We don't know what the other 2 options were.
But the one they chose.
The one they chose was, as the court described it, obscure and dubious. It was the decision to launch a criminal prosecution against Mr. Mann for the common law misdemeanor of maintenance.
Maintenance? We're not talking about alimony again, are we? Or fixing a house? No, definitely not. This is a really old, almost forgotten legal term, a crime. Maintenance, in this context, means improperly assisting someone else's lawsuit when you yourself have no legitimate interest or connection to it.
So, like, malicious meddling in someone else's legal fight.
That's a good way to put it. Improper meddling. The High Court, back in 1960, called the charge obscure and dubious. They said they couldn't find any reported cases of anyone actually being prosecuted for maintenance and living memory. It was basically a fossil of the legal world.
So why on earth did they choose that charge? This dusty old relic.
Well, that seems to have been part of the unethical genius of the plan, if you can call it that.
How so?
The sources are incredibly clear on this. The real goal of these prosecutions, they state, was admittedly devised as a means of intimidating that solicitor, meaning Mr. Mann.
So it wasn't about genuinely prosecuting a crime.
No. They were undertaken, the court said, with no other object in view than the elimination of Mr. Mann from the proceedings between the Jacombes. The general idea, as the High Court later summarized it, was to make a vigorous public attack on the professional character of Mr. Mann and hope for the best.
Hope for the best. Meaning hope that Mann would just quit.
Exactly. The hope was that Mr. Mann would be so intimidated, so scared of a public criminal trial, so worried about the damage to his reputation, that he would simply withdraw from representing Mrs. Jacombe. Get him off the case. And the problem, from Jacombe's perspective, disappears.
So the crime itself was irrelevant. It was the threat of the accusation, the public spectacle, that was the weapon.
Precisely. It was all legal theater, a calculated act of aggression designed purely to terrify and disable the opponent's lawyer. And, incredibly, Clyne himself was pretty open about this later on.
He admitted it.
Yeah, the sources quote him saying something like, they had taken a desperate and unusual course because they saw no other way to stop the litigation. Litigation which, he claimed, was only going on simply because a solicitor wants to make money.
Wow. So he tried to flip it, paint Mann, the target, as the greedy villain to justify his own extreme tactics.
That's exactly what he did, a remarkable piece of manipulation.
Yeah.
But the court saw right through it. The High Court described the whole thing, the entire enterprise, as irresponsible and mischievous. It wasn't a legitimate use of the law. It was a dangerous perversion of it.
Okay, so the strategy is locked in. use this bizarre, ancient criminal charge to launch a very public attack on Mr. Mann, scare him off, and hopefully make the civil cases collapse. How did they actually set this trap?
They moved incredibly fast. On January 14th, 1959, just weeks after Clyne seems to have been brought in, 4 criminal informations were laid.
Informations, that's the formal charge document, right?
Yeah, exactly. 4 of them laid by Mr. Jacombe against Mr. Mann. 1 information for each of those 4 key civil proceedings we talked about: the divorce, the equity suit, the property suit, and the alimony application.
And these were private prosecutions, started by Jacombe himself, not the police or the state.
That's right, which was highly unusual in itself. Private prosecutions for this extremely antiquated misdemeanor. Apparently, Clyne found the wording for the charge in Archbold, which is like a standard handbook for criminal lawyers.
Yeah.
The charges basically alleged Mr. Mann unlawfully maintained those specific civil cases.
And they got this into court quickly.
Super quick. A committal hearing was scheduled just a week later, January 21st to 23rd, 1959.
A committal hearing. That's like a preliminary check, isn't it? To see if there's enough evidence for a proper trial.
Exactly. It happens before a magistrate. The prosecution presents its evidence, and the magistrate decides. Is there enough here to send the accused person for trial in a higher court? This hearing took place in a Sydney magistrate's court.
Okay, picture the scene. Who is representing each side in this extraordinary hearing?
Right. On one side, you had Reuben Clyne. He was appearing as prosecuting counsel for the informant, Mr. Jacombe, instructed by Jacombe's new solicitor.
And defending Mr. Mann.
Mr. Mann wisely didn't represent himself. He engaged an independent solicitor who then instructed senior counsel for his defense. His barrister was Mr. McIntosh, QC.
McIntosh QC. Hang on, that name sounds familiar, wasn't he?
Yes, exactly. Mr. McIntosh, QC, was also Mrs. Jacombe's counsel in her civil suits against Mr. Jacombe. The divorce case, the other matter.
So Mann's defense lawyer already knew the whole messy background inside out.
Intimately. Which put him in a unique position to understand exactly what was really going on here. That this wasn't a genuine prosecution, but an attack.
The atmosphere in that courtroom must have been electric.
Oh, you can only imagine. Immense tension. Everyone knew what was at stake. For Mr. Mann, it was potentially everything. His reputation, his livelihood, his entire 40-year career as a solicitor. If he got committed for trial, let alone convicted, it could be utterly devastating.
And for Clyne and Jacombe?
Well, if the magistrate saw through the scheme, if it became clear this was just a shocking abuse of legal process using the criminal courts as a weapon in a private fight, the consequences for them could be severe too.
And this committal hearing, these 3 days in January 59, this is where the courtroom ambush really happened, where Clyne let loose.
This is the absolute core of the ethical misconduct. From the moment Reuben Clyne stood up to give his opening address to the magistrate, he executed the plan. The sources state it baldly. Clyne deliberately used the occasion to make a savage public attack on the professional character of Mr. Mann.
Savage public attack. There's that dramatic phrase again. It wasn't subtle.
Not in the slightest. Clyne wasn't just questioning Mann's judgment or making nuanced points. He launched into the most serious allegations possible. And he did it in extravagant terms, accusing Mann of fraud, perjury, and blackmail.
These weren't just claims of bad lawyering. These were accusations of serious crimes and gross professional dishonesty.
Exactly. And here's the absolute crucial point, the one the sources hammer home again and again.
What's that?
Clyne knew he had no evidence to substantiate such allegations. He knew it. He wasn't opening a case he genuinely believed he could prove. He was making these incredibly damaging claims, knowing full well he couldn't back them up with actual proof.
And this is where that whole concept of abusing a barrister's privilege comes right into play, isn't it?
It's absolutely central. Barristers have this thing called absolute privilege. It means they generally can't be sued for defamation for things they say in court while doing their job.
Why is that privilege so important?
It's vital, really. It lets advocates speak fearlessly for their clients. They can challenge witnesses, present difficult arguments, maybe even uncomfortable truths without constantly looking over their shoulder, worrying about being sued personally. It's meant to be a shield, protecting fearless advocacy in the pursuit of justice.
But Clyne wasn't using it as a shield here.
No. The sources say he was wielding it as a sword to besmirch a colleague's reputation with impunity. He knew he couldn't be sued for the terrible damage he was inflicting on Mr. Mann's character and professional standing. He was exploiting a protection designed for the proper administration of justice.
For a personal attack.
Exactly. A personal attack completely lacking a factual basis. This conduct, the sources state plainly, was utterly beyond the pale.
Okay, this is fascinating in a horrifying way. Let's really dig into the specific baseless allegations Clyne threw out there. The High Court analyzed 5 main ones later, right? What was the first big one?
The very first allegation, the one Clyne put right at the forefront of his case in his opening speech, was that Mr. Mann was in serious financial difficulties.
Why would that matter?
Clyne claimed Mann was in trouble because he'd apparently undertook to pay large sums as a result of his partner's defalcations. Defalcations meaning, like, embezzlement.
Okay, so a partner had stolen money, and Mann was on the hook.
That was the claim. And Clyne alleged this financial trouble gave Mr. Mann a motive, a desperate need for cash, which, according to Clyne, induced Mann to improperly maintain litigation, basically, drum up or drag out lawsuits purely to generate excessive legal fees for himself.
Right. Painting Mann as desperate for money because of a dodgy partner, implying this drove him to act unethically, even criminally. Was there any evidence for this serious claim?
The only piece of evidence Clyne could offer came from a police sergeant, Sergeant Cannicott. He'd investigated the embezzlement by Mann's partner some time before. Sergeant Cannicott testified he'd had a conversation with Mr. Mann, but this was over 18 months earlier, before May 1957, way before the Jacombe matters really kicked off.
Oh.
In that old conversation, Mann had mentioned a deficiency about 13,000 pounds related to the partner's actions, and Mann had said he'd meet it if they, the amounts, were at any stage shown to be a liability of the partnership.
So an old conversation about a potential conditional liability from ages ago. What did the court make of that as proof Mann was currently desperate and committing crimes for costs?
The High Court later found it obviously impossible to infer any such thing. They completely dismissed it, calling the suggestion an outrage. It was a massive, unsupported leap from an old chat about a maybe liability to claiming Mann was in dire financial straits driving him to crime now.
And Clyne tried to excuse making this claim without proof, didn't he? What was his justification?
He did, yeah. Later, in a letter he wrote to the Bar Association trying to explain himself, he claimed he was entitled to make the allegation in his opening because he'd served a subpoena on Mr. Mann. He was hoping, basically, to find evidence of financial trouble in Mann's own account books.
He subpoenaed the guy he was prosecuting?
Yes, but the court found this excuse absurd. Mr. Mann was the defendant in a criminal proceeding. He wasn't a compellable witness. He couldn't be forced to hand over documents that might incriminate himself. That's fundamental.
So the excuse just showed?
It showed he had no proof. The court said this excuse was really just a confession by the appellant that he was not in a position to prove the grave allegation which he was making. He admitted he made the accusation first, hoping the evidence might magically appear later.
That's shocking for a lawyer to admit. Just incredible.
It really is. And Clyne didn't even stop there on this point. When Mr. Mann's lawyer, McIntosh QC, pointed out in court that the subpoena documents hadn't actually been produced, Clyne did something even worse. He outrageously suggested to the magistrate that the reason Mann hadn't produced the documents could only be one of two things. Either Mann was in contempt of court, or the documents would actually incriminate him.
So he twisted the lack of evidence for his claim into an insinuation against Mann.
Exactly. The High Court called this inexcusable. He turned his own lack of proof into a suggestion that Mann was either defying the court or hiding guilty secrets. Just astonishing stuff.
All right, that's the first baseless allegation, the financial desperation claim. What was the second major one Clyne made against Mann?
This one involved the application for interim alimony we mentioned earlier.
Yeah.
Clyne alleged that the court order granting alimony was actually procured by fraud.
Fraud?
He claimed it was based upon an affidavit prepared by the defendant, meaning Mr. Mann, and with his knowledge sworn by Mrs. Jacombe, an affidavit which was false. He was basically accusing Mr. Mann of being an accessory to perjury, helping his client lie under oath.
What was supposedly false in Mrs. Jacombe's affidavit?
Her affidavit supporting the alimony claim included statements like, "I have no income, no money in the bank, and no means whatsoever." Standard stuff in alimony applications. Clyne claimed every single one of those statements was false, and false to the knowledge of the defendant. False, and Mann knew it.
Okay, serious claim. Did Clyne actually produce any evidence linking Mr. Mann personally to preparing a supposedly false affidavit?
None whatsoever. The sources are emphatic. Clyne adduced no evidence whatever to connect Mr. Mann personally in any way with the affidavit.
So no proof Mann even wrote it, let alone knew it was false.
Right. The court pointed out it was just as likely, probably more likely, that it was drafted by a clerk in Mann's office based on Mrs. Jacombe's instructions. That's common practice.
And was the affidavit itself even materially false? Did she actually have income or means?
Well, according to the court's later analysis, there was no evidence that Mrs. Jacombe had at the date of the affidavit any income or any means.
What about money in the bank?
She did have 11 pounds in her bank account. 11 pounds. But the court made the rather dry observation that, quote, to a woman accustomed, as Mrs. Jacombe was, to wealth, the difference between nothing and 11 pounds might well have seemed immaterial. It certainly wouldn't have changed the alimony amount.
Any other points?
She had also received about 490 pounds from Mr. Jacombe before she swore the affidavit, but the court said the mere fact of those payments did not falsify her affidavit. She was declaring her current means, not giving a full historical accounting.
So basically, no evidence Mann was involved and barely any evidence the affidavit was even meaningfully false.
Pretty much. Yet Clyne had stood up and accused Mann of being an accessory to perjury. The court noted Clyne seemed to see nothing wrong in saying he would prove this, despite having absolutely no foundation for the claim.
Another serious accusation, zero proof. What was the third major allegation against Mann?
The third one was that Mr. Mann was deliberately dragging out the litigation, protracting it, as the legal term goes, and doing it purely for his own benefit to rack up costs.
How is he supposedly doing that?
By refusing to give particulars in the divorce suit.
Particulars? What are they in this context, and why would refusing them be such a big deal, let alone criminal?
Okay, so particulars in litigation are basically specific details about the claims being made. The background here was pretty messy. Mr. Jacombe was actually denying that their marriage was even valid.
Denying the marriage itself?
Yes. He was suggesting that Mrs. Jacombe's previous husband might still have been alive and still legally married to her when she married Mr. Jacombe. If true, that would make her marriage to Jacombe null and void.
Right, okay. So where do the particulars come in?
Mr. Jacombe's solicitors asked Mr. Mann for particulars about this previous husband. Specifically, were they alleging he was dead or divorced at the time Mrs. Jacombe married Mr. Jacombe.
And Clyne claimed Mann refused to give these details just to delay things and make more money.
That was the allegation. But the court later found this one even more fantastic than the others. They pointed out a few things. First, this probably wasn't even a matter for particulars in the strict legal sense. Second, if Mr. Jacombe genuinely doubted the marriage's validity, he could have just formally raised it in court documents himself. And third, even if particulars were needed, a simple court application, a summons, could have sorted it out very quickly, in days probably.
So refusing wasn't really holding anything up significantly?
Not really.
Yeah.
But more fundamentally, the court asked, why should Mann just hand over information when Mr. Jacombe was denying the marriage entirely, implying his own child might be illegitimate, and basically forcing Mrs. Jacombe to prove the marriage's validity in court anyway?
Good point.
The court called it a monstrous thing to assert that a solicitor who refused information, in those circumstances, was doing it just for the purpose of protracting proceedings and making costs for himself. It just didn't stack up.
It sounds like Clyne was twisting a normal, maybe even necessary procedural stance by Mann into some kind of greedy criminal act. Okay, what was accusation number 4?
Number 4 was that Mr. Mann had refused or neglected to negotiate a settlement with Mr. Jacombe or his lawyers. And surprise, surprise, Clyne attributed this again to Mann's supposed desire to just keep the litigation going to maximize his costs.
And what was the basis for this accusation? Any proof Mann refused to talk?
The sole basis Clyne offered for this serious claim was the fact that neither Mrs. Jacombe nor Mr. Mann had replied to that extraordinary letter Mr. Jacombe had sent his wife back on September 6th.
The threatening letter. The one where Jacombe tried to pressure her into settling on his terms by threatening her divorce, alimony, and custody claims.
That's the one. Because Mann didn't engage with that letter, Clyne accused him of refusing to negotiate, driven purely by greed.
That seems completely backwards.
It is. The court was utterly scathing about this. First, they said there was zero evidence Mann had even seen the letter when it was sent. Second, even if he had seen it, what responsible solicitor would engage with a letter like that?
Right. It was basically a threat.
Exactly. The Chief Justice even thought it might amount to collusion, trying to improperly fix the outcome. The court said any responsible solicitor, faced with such an extraordinary letter, would certainly advise his client to ignore it, or maybe send a minimal reply saying the client wouldn't be intimidated.
So, accusing Mann of misconduct for not responding to a threatening, possibly collusive letter was...
utterly baseless, ethically perverse, really. A lawyer's job isn't to help the other side bully their client into a bad deal. It's the exact opposite. To accuse Mann of misconduct for doing his job properly in that situation was just another unfounded attack.
Okay, right. That leaves the fifth major baseless allegation the High Court looked at. What was this one?
This fifth accusation was that Mr. Mann was conducting legal proceedings that he knew were hopeless. Specifically, Clyne pointed to two of the four main cases: the Section 66G property suit over Linton Manor and the equity suit where Mrs. Jacombe was seeking an account of monies.
Hopeless, meaning no chance of success.
That was Clyne's claim. He alleged Mann was running these cases without any real expectation of his client winning, or even being able to pay his fees directly, purely to generate costs for himself from the overall pot of marital assets, presumably.
What about the other two main cases, the divorce and the alimony application? Did Clyne claim they were hopeless too?
No. The sources are clear on this. Even Clyne couldn't realistically pretend those were frivolous or hopeless. Mrs. Jacombe clearly had grounds for divorce based on the undenied adultery, and seeking interim alimony was a standard, legitimate step in that process.
So the hopeless litigation attack focused only on the property suit and the equity suit. Were they actually hopeless? What did the court think?
Not according to the courts, no. Let's take the Section 66G suit first, the one to sell the jointly owned house, Linton Manor. The court noted Mrs. Jacombe was clearly prima facie entitled to an order.
Prima facie, meaning?
Meaning on the face of it, based on the law and the fact she was a joint owner, she had a valid claim to have the property sold or divided.
But Clyne called the suit vindictive, didn't he? Said she was just doing it out of spite.
He did. But the court dismissed that argument too. They said, there's no real reason for saying that Mrs. Jacombe was inspired by vindictive motives. Selling a large family home after marriage breaks down, especially when there's lots of other litigation, seemed perfectly reasonable to them as a way to divide assets.
And even if she was motivated partly by ill will.
The court made a key point. It is obviously not misconduct for a solicitor to act for a client who has a perfectly good cause of action, but is inspired by ill will towards the defendant. A lawyer can absolutely act for someone who has a legitimate legal right, even if the client doesn't like the person they're suing. Bad feelings don't make a valid lawsuit improper.
Okay, but Clyne had another angle on the property suit being hopeless, didn't he? Something about Mr. Jacombe lending her money.
Yes. Clyne suggested the suit couldn't actually benefit Mrs. Jacombe anyway. He claimed Mr. Jacombe had lent her half the purchase money for Linton Manor, and that Mr. Jacombe's claim to get that loan back would essentially wipe out her share of the sale proceeds. So she'd get nothing, making the suit pointless for her, and thus, Clyne argued, Mann must only be running it for costs.
And the court's reaction to that argument?
They found this allegation by Clyne thoroughly disgraceful.
Disgraceful? Or why such strong language?
For a few reasons. First, they said there was no evidence that Mr. Mann knew anything about this alleged loan from Mr. Jacombe. Second, even if Mann did know about the allegation, he might have had instructions from Mrs. Jacombe leading him to doubt whether the loan claim was even true.
Okay.
And third, critically, even if the loan claim was true, Mrs. Jacombe could still well derive a very substantial benefit from the property sale if its value had increased significantly since it was bought. Her share of the capital gain could still be worthwhile, even after repaying an alleged loan.
Right, so it wasn't necessarily pointless for her at all?
Exactly. So for Clyne to stand up in court and publicly state that Mr. Mann was conducting this suit solely for costs, knowing it couldn't possibly benefit his client, that was completely without foundation. And in the court's view, disgraceful conduct for a barrister to make such a serious, unsupported claim.
Okay, what about the other allegedly hopeless case, the equity suit, the one for an account of monies?
Right. Now this one, Mrs. Jacombe did face a significant legal hurdle. There was a deed signed back in 1956. In this deed, she had apparently released Mr. Jacombe from claims like this and acknowledged that certain property held in her name was actually held in trust for him.
And she'd signed this deed with lawyers involved.
Yes, it was executed in the presence of a solicitor. So This deed definitely looked like a strong defense for Mr. Jacombe. A prima facie defense, the court called it. On the face of it, it seemed to block her claim.
So maybe this suit was a bit hopeless.
Well, the court acknowledged the deed was an obstacle. But, they said, it is a far cry from saying this to saying that a solicitor who acts for a wife in a suit which cannot succeed unless a deed between her and her husband is set aside is acting purely in his own interests or is in any way guilty of misconduct.
Meaning, just because a case is difficult or requires overcoming a hurdle like setting aside a deed doesn't automatically make it improper for a lawyer to take it on.
Exactly. Maybe Mrs. Jacombe had grounds to challenge that deed.
Yeah.
Perhaps she signed it under duress or without proper advice. Who knows? The point is, Clyne had no idea what Mr. Mann's instructions were or what the merits of challenging that deed might be. So again, there was no evidence whatever to support Clyne's accusation that Mann was pursuing this potentially difficult but not necessarily impossible suit purely for his own costs.
So looking back at all five, accusations of financial desperation driving crime, complicity in perjury, deliberately protracting litigation for greed, refusing to negotiate out of greed, and running hopeless cases purely for costs. And Clyne had literally zero evidence to back up any of them.
That's the absolutely critical finding the courts made later. Zero evidence. But Clyne didn't just make these bare allegations, did he? He wrapped them up in some incredibly inflammatory language.
Yeah, the sources called them extravagant characterizations of the most offensive and damaging nature. Let's hear some of those actual quotes. This is where you really feel this savage attack.
Absolutely. Right near the start of his opening address to the magistrate, Clyne dropped this bombshell. The essence of the charge against the defendant is he is using his own client as an instrument of blackmail against a wealthy man in the hope of extracting money.
He accused Mann, the solicitor, of using his own client, Mrs. Jacombe, as a tool for blackmail against her husband.
Directly, calling his professional colleague a blackmailer, essentially.
Believable. What else?
He described that equity suit, the one with the deed issue, as being brought utterly without any foundation or responsibility. Just completely baseless, he claimed. On the alimony order, he repeated the perjury accusation in stark terms. It was procured by fraud upon an affidavit prepared by the defendant and with his knowledge sworn by Mrs. Jacombe, an affidavit which was false. Just hammering that point home without proof.
And he even twisted Mr. Jacombe's own threatening letter against Mann, didn't he?
Yes. That letter Jacombe sent his wife back in September 58. Clyne referred to it and claimed it contained offers which no responsible solicitor could have failed to advise his client to accept.
So he was implying Mann was irresponsible or acting improperly because he didn't advise Mrs. Jacombe to cave in to her husband's threats and maybe even collude with them.
It's completely perverse logic, isn't it? And then there were payments Mann had handled for Mrs. Jacombe, proceeds from selling some of her jewelry. Clyne took that perfectly normal transaction and claimed those monies were paid to Mrs. Jacombe in such a way that she became a tool in the hands of the defendant, meaning Mann, for the purpose of bringing proceedings against a wealthy man.
Accusing Mann of manipulating his client with her own money to attack her husband.
Yes. The court later described this specific accusation as alleging the grossest possible professional dishonesty, and noted it was made deliberately without the slightest foundation.
He also attacked Mann's reputation directly, didn't he? Questioned his standing.
He did. He made this sweeping statement that all the difficulties between the informant and his wife can be settled on a basis that is fair and equitable if Mrs. Jacombe had the advice of an independent and reputable solicitor.
Implying Mann wasn't independent or reputable.
Exactly. And this was aimed at Mr. Mann, who, the court pointed out, was a solicitor with 40 years of experience at that point. The suggestion he wasn't independent and reputable was, the court said, entirely without foundation.
So Clyne wasn't just attacking Mann's specific actions in the cases. He was systematically trying to tear down his entire professional character and standing in a very public forum.
That's precisely what was happening. And he finished his opening address with this really vivid, really cutting analogy. He said, in conclusion, this is an informant, meaning Mr. Jacombe, who is regarded by the defendant, meaning Mr. Mann, as the goose most likely to lay a large number of golden eggs if it is squeezed.
Wow. Painting Mann as this greedy predator, just squeezing money out of the situation through endless litigation. Deeply insulting.
Incredibly insulting, and again, totally unsupported by evidence.
Yeah.
It was just pure, poisonous rhetoric designed to destroy Mann's reputation.
So this wasn't just zealous advocacy getting a bit heated. This was a calculated, baseless demolition job using privilege and inflammatory language. And he didn't even stop there, did he? He actually issued a direct threat right there in court.
He did. And this element, this threat, was something the courts later found particularly damning. Clyne didn't just attack Mann's character. He made a direct, barely concealed threat to Mr. Mann and his counsel, Mr. McIntosh QC.
What was the threat?
He essentially stated that if Mr. Mann stopped acting for Mrs. Jacombe, then the criminal proceedings against Mann would have achieved their object and could be discontinued.
He actually said that in open court. Basically, if the opposing lawyer quits, I'll drop these criminal charges.
Yes, explicitly. In his opening address, he stated, I say, if Mrs. Jacombe or Mr. Mann undertakes to allow her consult an independent solicitor, this matter could be settled within 48 hours. Then he added this justification. We have taken the course which may seem desperate and unusual because we can see no other way of avoiding litigation which is going on in a number of courts simply because a solicitor wants to make money.
So he openly admits the tactic is desperate and unusual, states the goal is just to stop the litigation, and pins it all on the opposing lawyer being greedy.
Exactly. And he wasn't finished. He apparently turned directly to Mr. McIntosh QC, Mann's defense counsel, right at the end of his opening, and said something like, have Mr. McIntosh instructed by an independent solicitor who acted in Mrs. Jacombe's interest, he and I would probably have this case settled over lunch.
That is just breathtaking. He's using the platform of a criminal prosecution, abusing his role as prosecuting counsel, to try and bully Mrs. Jacombe into firing her lawyer, offering to drop baseless charges if his opponent's lawyer just quits the case.
It really is extraordinary, and this conduct, this threat, is precisely what the sources in the courts later condemned as being akin to legal blackmail.
Legal blackmail?
Yes, using the threat of criminal prosecution not for justice, but to force a specific outcome in a private civil dispute. And in doing so, treating his own client, Mr. Jacombe, as an instrument of blackmail against Mr. Mann by engineering these proceedings solely for that coercive purpose.
He basically manufactured this whole atmosphere of intimidation and public humiliation, didn't he?
Yeah.
Using the protection of the court, the privilege of being a barrister, for a completely improper, destructive purpose.
That sums it up perfectly. He exploited his absolute privilege, threw around wild, baseless accusations of the most serious kind, and aimed to destroy a colleague's integrity and career, all dressed up as legitimate legal procedure. The High Court later said he was effectively putting Mr. Mann on trial in the court of public opinion during what should have been a straightforward preliminary hearing. For a barrister, this kind of behavior, as the sources repeat, was utterly beyond the pale.
So after this incredible performance by Clyne, what happened next? Did the magistrate see through it immediately, or did Clyne's ambush actually work, at least in the short term?
Well, in a really quite surprising turn, Clyne's dramatic, unethical tactics actually succeeded. Partially, at least in that magistrate's court.
Really? The magistrate bought it?
It seems so. Perhaps the magistrate was just overwhelmed by the sheer obscurity of the maintenance charge, maybe swayed by the volume and severity of the allegations coming from a barrister, or maybe just didn't have the full context the higher courts would later have. But whatever the reason, at the end of that 3-day hearing, the magistrate concluded there was at least a case to answer.
So, Mr. Mann was committed for trial.
Yes, Mr. Mann was committed to stand trial in a higher court on all 4 counts of criminal maintenance.
Wow. So the courtroom ambush, the baseless claims, the threats, it actually worked to the extent that Mann was now facing a full-blown criminal trial.
It did up to that point. The High Court later commented how extremely regrettable it was that Mr. Mann was committed for trial based on such flimsy grounds and this archaic, unused charge. But the magistrate's decision was made. It meant Mr. Mann now faced the enormous stress, the cost, and the potential career annihilation of defending himself against criminal charges.
But being committed for trial isn't the final step, is it? The actual prosecution still has to be formally initiated by the state authorities.
That's exactly right. Committal by a magistrate just means they think there's enough evidence to warrant a trial. The case files then automatically go, as standard procedure in criminal matters, to the Office of the Attorney General. They make the final call on whether the Crown, the state, will actually proceed with the prosecution.
And what did the Attorney General decide in this case?
Well, in March 1959, just a couple of months after the committal hearing, the Attorney General's office reviewed the whole case, and they made a very clear, decisive intervention.
Which was?
The Attorney General flatly refused to proceed. They issued what's called a nolle prosequi.
Nolle prosequi. Can you translate that from the Latin for us?
Sure. It basically means we do not wish to prosecute. It's the formal declaration by the Crown prosecutor that they are dropping the case, stopping the criminal proceedings.
So the Attorney General saw it for what it was, a manufactured, baseless prosecution.
Exactly. They looked at the evidence, or lack thereof, the obscure charge, the whole context, and put a stop to it. Sanity, as the sources put it, prevailed in the form of the Attorney General's office stepping in.
So the criminal threat hanging over Mr. Mann was finally lifted.
Yes. The criminal case against him was officially over. It would never proceed to trial. But, as the sources pointedly note, while sanity prevailed, the damage had been done.
How so?
Well, Mr. Mann's name had been dragged through the mud in a public courtroom. His integrity had been savaged over 3 days by Clyne's baseless attacks. He'd endured the immense stress of facing criminal charges and being committed for trial. The stain, even if ultimately removed, had been applied.
What did Mr. Mann do in response to this whole ordeal? Did he just try to forget it?
No. Admirably, Mr. Mann withstood the attack. He didn't buckle under the pressure. He didn't withdraw from representing Mrs. Jacombe. And the sources mention he didn't just let it go either. He later took legal action against Mr. Jacombe personally.
Suing Jacombe? For what?
For malicious prosecution. Basically, suing him for damages caused by Jacombe engineering those baseless criminal charges against him. Though, the sources note, the outcome of that case is another story, and not central to the Clyne disbarment matter we're focused on.
Okay. So Mr. Mann was ultimately clear of the criminal charges and fought back against Jacombe. But what about Reuben Clyne? Surely he couldn't just get away with orchestrating that whole appalling episode.
Absolutely not. His conduct in that magistrate's court was just far too blatant, too egregious, too clear an abuse of his position as a barrister to be ignored by the legal profession's own watchdog.
The Bar Association.
Exactly. The New South Wales Bar Association, which is the professional body responsible for regulating the conduct of barristers in the state, took very decisive action. They applied to the Supreme Court of New South Wales, the highest court in the state, to have Reuben Clyne's name struck off the roll of barristers.
Struck off, meaning disbarred.
Yes, disbarred. Removed from the profession. The grounds for their application were essentially that his conduct, particularly in the Mann prosecutions, demonstrated he was not a fit and proper person to practice as a barrister.
So the fight shifted from the criminal court targeting Mann to a professional disciplinary hearing in the Supreme Court targeting Clyne himself.
Precisely. The spotlight turned directly onto Clyne's own conduct.
And this brings us to the next stage, the reckoning. The Supreme Court hearing for Clyne's disbarment.
That's right. The Bar Association's application against Clyne came before the full court of the Supreme Court of New South Wales, usually a panel of 3 or more senior judges, sometime in mid-1959. The case was formerly known as Bar Association of NSW v. Clyne.
Who are the lawyers involved in this hearing, representing the Bar Association and Clyne?
Okay, the Bar Association, as the applicant seeking to disbar Clyne, was represented by 2 senior barristers, Mr. R.G. Reynolds, QC, and Mr. B.B. Riley.
QC meaning Queen's Counsel, a senior barrister.
Exactly. And Clyne, who was the respondent defending his right to practice, was also represented by retained counsel. The source doesn't actually name the specific barrister representing him at this Supreme Court stage, only for the later High Court appeal. But he was instructed by the solicitors Rishworth, Dodd, and Einfeld.
And Clyne didn't argue his own case here.
No, importantly, he had his own legal team representing him before the Supreme Court. He wasn't acting for himself at this point.
What evidence did the Bar Association put before the Supreme Court judges?
They essentially laid out the whole story of Clyne's conduct during the committal hearing for Mr. Mann. They presented detailed transcripts of his inflammatory opening address, showing the baseless accusations, the extravagant language, the threats he made. They also likely presented letters Clyne had written afterwards where he tried to justify what he'd done.
And how did Clyne's legal team try to defend him? Did they offer excuses for his behavior?
They did try. They relied on some of the explanations Clyne had offered, like his claim about serving the subpoena on Mr. Mann, hoping to find evidence in his books. The argument was presumably that his actions, while perhaps robust, were somehow excusable or fell short of misconduct warranting disbarment.
How did the Supreme Court react to those excuses?
They utterly rejected them. They found his explanation about the subpoena in particular actually made matters worse. Why? Because it amounted to a direct confession by Clyne that he had no actual proof when he made that incredibly grave allegation about Mr. Mann's financial difficulties driving him to commit crimes. It blew up his own defense.
So the court dug deep into why Clyne's conduct was so unacceptable. What were their main findings about his misconduct?
The judges conducted a really careful analysis. They found, first and foremost, that he had clearly engaged in an abusive court process.
Abusive process? How so?
They said he deliberately chose that obscure and dubious offense of maintenance, not for any legitimate reason, but specifically as a tactical weapon, a way to intimidate Mr. Mann. They found he abused the process of the court because he used a criminal proceeding for a purely ulterior motive.
Meaning not to genuinely prosecute a crime, but just to achieve something else entirely.
Exactly. His motive wasn't justice. It was solely to intimidate Mr. Mann into dropping out of the civil cases. The court pointed out that If Mr. Jacombe genuinely thought Mann was acting improperly, or that the civil cases were frivolous, there were proper, legitimate ways to deal with that.
Like what?
Like applying to the civil court judge to stay the proceedings as an abuse of process. Or if he thought Mann had acted unethically as a solicitor, he could have made a formal complaint to the Law Society, the body that regulates solicitors.
But Clyne and Jacombe didn't do either of those things.
No. They bypassed those established proper channels, and the court concluded they likely chose the path of a private criminal prosecution precisely because it offered, as the judges put it, opportunities for a public attack on Mr. Mann. The goal wasn't a fair resolution, it was public destruction, using a legal tool improperly.
And the court also focused heavily on his misuse of that barrister's privilege, the absolute immunity thing.
Oh, absolutely. This was completely central to the court's condemnation. They stressed that, yes, the privilege is vital for fearless advocacy, but it's not an unlimited license to smear people.
And Clyne had crossed that line.
Grossly abused it, was the finding. He deliberately injected damaging, irrelevant matter, all those baseless accusations of fraud, perjury, blackmail into the hearing, knowing perfectly well he couldn't back them up with any evidence. The High Court later neatly summarized the Supreme Court's view on this. The privilege may be abused if damaging, irrelevant matter is introduced. It is grossly abused if counsel, in opening a case, makes statements which may have ruinous consequences to the person attacked and which he cannot substantiate or justify by evidence. Clyne's actions were the textbook definition of that gross abuse.
And the court identified a specific fundamental rule that Clyne had just ignored.
Yes. The Supreme Court judges emphasized that every responsible barrister knows one fundamental rule. You must not present allegations in court that you cannot support with evidence. It's basic, and they found Clyne had flagrantly broke this fundamental rule. A barrister's duty to the court demands honesty, candor. Making incredibly serious, damaging accusations you know you can't prove is a direct assault on that duty.
Now, the Supreme Court didn't just see this as a one-off terrible mistake, did they? They saw a worrying pattern of behavior.
This is a really crucial factor in their decision. The court highlighted two earlier incidents, both from 1957, that showed this wasn't an isolated lapse in judgment. It demonstrated a disturbing pattern and, worryingly, a disregard for previous warnings.
Okay, what was the first incident from 1957?
This happened in April 1957, about 2 years before the Mann case erupted. Clyne was acting as defense counsel in a jury trial before a judge named Justice Manning. In his opening address to the jury, Clyne made some very serious, damaging accusations against the plaintiff in that case, just like he would later do with Mr. Mann.
And then what happened in the trial?
Crucially, after making these big accusations in his opening, Clyne then called absolutely no evidence during the trial to support them. He just made the claims and then offered nothing to back them up.
And did the judge notice this? Did Justice Manning react?
Oh, he reacted all right. Justice Manning delivered a very stern, very public judicial rebuke to Clyne right there in court. He said, and this is a direct quote included in the later judgments, "You made a most serious allegation of impropriety, fraud, crookery, and you sit down and close your case without one word of evidence to support it. You are never entitled to open a highly prejudicial matter on the hope that you be able to get some admissions. I think it is quite improper."
Wow. A direct dressing down from a judge.
Absolutely. The Supreme Court in the disbarment case called this a direct and severe judicial warning about exactly the very kind of conduct, making unsupported allegations in an opening that was now being complained of in the Mann prosecutions. He'd been explicitly warned about this exact thing before.
Okay, so he was directly warned by a judge in April 57, but the pattern continued. What was the second incident the Supreme Court noted from 1957?
This one happened just a few months later. In September 1957, Clyne found himself hauled before the Supreme Court again, this time on different charges of unprofessional conduct.
Was this case as serious as the attack on Mann?
No. The source describes the conduct in this September 57 case as much less serious. The main issue then, the real gravamen of the complaint, was apparently that Clyne had engaged in behavior that amounted to advertising his services as a barrister.
Advertising. That was unprofessional back then.
Yes, at the time, barristers' advertising was considered wholly inconsistent with the conduct of a professional man. It was a breach of professional etiquette and rules. So, less about courtroom integrity, more about how he presented himself professionally outside the court.
But the Supreme Court still took it seriously.
They did, seriously enough that they were considering disciplinary action. However, in that specific instance, The charges against Clyne were ultimately withdrawn.
Why were they withdrawn?
They were withdrawn after Clyne gave a formal undertaking to the court.
An undertaking.
Oh.
That sounds important. What does that mean, giving an undertaking to the Supreme Court?
It's a very big deal for a lawyer. It's a solemn promise made directly to the court itself, a promise to behave in a certain way or to not behave in a certain way in the future. It carries significant weight.
And what did Clyne promise the court in September 1957?
He gave an undertaking to abide by the recognized standards which should govern the conduct of members of the profession. Basically, he promised to follow the rules and ethics expected of a barrister. And importantly, the sources note that Clyne himself assured the court at that time that he had a clear conception of what his obligations were regarding professional conduct.
Okay, let me get this straight. In 1957 alone, first, he gets a direct, severe warning from a judge about making unsupported allegations in court. Then, just months later, he gives a formal, solemn promise to the Supreme Court itself to uphold professional standards, saying he understands his obligations. Yet, just over a year later, he goes and commits the exact same type of misconduct, making damaging, unsupported allegations, but on a massively escalated, far more serious scale against Mr. Mann.
That is precisely the disturbing pattern the Supreme Court identified. He'd been warned. He'd given his word to the highest court in the state. And yet, he repeated and drastically worsened the very same behavior. It showed, in the court's view, a clear disregard for ethical standards, a failure to heed judicial correction, and a blatant breach of a formal promise made to the court.
Given that history, combined with the absolutely blatant conduct in the Mann committal hearing, what was the Supreme Court's final conclusion about Clyne?
The court found that this pattern of behavior, culminating in the egregious misconduct during the Mann hearing, demonstrated a fundamental lack of regard for the essential ethical standards required of a barrister. They concluded, unequivocally, that his actions constituted grave professional misconduct. And based on that, they found he was simply not a fit and proper person to practice as a barrister.
And the ultimate decision flowing from that conclusion.
On December 8, 1959, the full court of the Supreme Court of New South Wales ordered that Reuben Clyne's name be struck off the roll of barristers. He was disbarred. His career as a barrister in NSW was over.
What was the court's specific reasoning for imposing the ultimate professional penalty, taking away his right to practice law entirely?
They really emphasized that this was a glaring abuse of a barrister's position and the special privileges that come with it, especially the privilege of absolute immunity for statements made in court. But they also stressed a really crucial point about why they disbar lawyers. That disbarment is in no sense punitive in character. It's not primarily about punishing the individual lawyer for their past bad actions, although obviously it has that devastating effect. Instead, the court said, disbarment orders are made from the public point of view for the protection of those who require protection protection from lawyers deemed unfit or untrustworthy to practice.
So it's about protecting the public?
Yes, and also protecting the profession itself. The court added it's made from the professional point of view in order that abuse of privilege may not lead to loss of privilege for all barristers. If abuses like Clyne's were tolerated, it could undermine the very justification for having that privilege in the first place.
So in a case this bad...
In a case involving such grave misconduct, such a fundamental abuse of privilege, the court stated firmly that only disbarment could meet the necessary standard. It was the only way to protect the public and uphold the integrity of the profession.
A really powerful message. Disbarment isn't just punishment, it's a necessary act of protection. Abuse your privilege, you forfeit it.
That's the core message. The Supreme Court's decision was firm, it was clear. But Reuben Clyne wasn't ready to give up just yet. He decided to fight on.
Which leads us to the final act in the legal drama, the appeal to the High Court of Australia.
Exactly. Reuben Clyne appealed the Supreme Court's disbarment order to the High Court of Australia, which is, of course, the highest court in the entire country. This ultimate appeal is the case that became famously known as Clyne v. NSW Bar Association, heard in April 1960.
Who sat on the High Court bench for this final critical appeal? These are the top judges in Australia deciding his fate.
It was a very distinguished bench, yes. 5 High Court justices heard the appeal. The Chief Justice himself, Sir Owen Dixon, along with Justices McTiernan, Folligar, Menzies, and Windeyer. A formidable panel.
And who were the lawyers arguing the case before the High Court?
Clyne, as the appellant trying to get the disbarment overturned, was again represented by counsel. The source names his solicitors for this appeal as Rishworth, Dodd, and Einfeld. His counsel wasn't named in the judgment summary we have, but he didn't argue it himself.
Okay. And the NSW Bar Association, defending the disbarment order.
They were the respondent, yes. And they were represented by the very same senior counsel who has successfully argued the case for them in the Supreme Court, Mr. R.G. Reynolds, Q.C., and Mr. B.B. Riley. They were there to defend the decision and uphold the standards of the profession.
Now, the source mentions a small preliminary point about jurisdiction, something about whether the appeal was automatic.
Yes, a slight technicality. Clyne's team initially tried to argue the appeal came to the High Court as of right, meaning automatically, because the value of his ability to earn income as a barrister exceeded a certain monetary threshold required for automatic appeals back then.
And the High Court agreed with that.
No, the High Court clarified that a disbarment order isn't really about a monetary sum being disputed in that way. It's fundamentally about a person's fitness to practice law. So technically, an appeal didn't lie as of right, based on money. However, the court immediately turned around and granted him special leave to appeal anyway.
Why grant leave if it wasn't automatic?
Because the case was obviously incredibly important. Important to Clyne personally, of course, but also, as the court said, of great importance to the legal profession and to the public. They clearly wanted to hear the arguments fully and deliver a definitive ruling on such significant ethical issues.
Okay, so the appeal went ahead. What was the High Court's final decision?
On June 21st, 1960, the High Court delivered its judgment. And it was unanimous. All 5 justices agreed. They emphatically affirmed the Supreme Court's original order disbarring Clyne. His appeal was dismissed, utterly rejected.
So they completely backed the Supreme Court's condemnation of his conduct. No sympathy for Clyne at all.
None whatsoever. The High Court judgment, which was delivered by the Chief Justice, Sir Owen Dixon, didn't just agree with the Supreme Court. It strongly reinforced and even amplified the reasoning. They went through Clyne's core unethical behavior again.
Such as?
Such as using his client, Mr. Jacombe, as an instrument of blackmail, specifically to cow Mr. Mann, intimidate him into submission. They found this conduct utterly incompatible with the ethical obligations of a barrister. They agreed his choice to use that obscure and dubious maintenance charge was improper. They criticized him again for bypassing the proper, legitimate procedures that were available, like applying to stay vexatious civil proceedings or lodging a professional conduct complaint against Mann with the Law Institute, the solicitor's body.
And they agreed on why he likely chose the criminal route.
Yes. Just like the Supreme Court, the High Court noted Clyne likely chose the criminal prosecution path precisely because of the opportunities which it offered for a public attack on Mr. Mann. Again, the motive wasn't justice. It was tactical destruction via public smearing.
And they were equally critical of his abuse of privilege and the fact he'd ignored previous warnings.
Absolutely. The High Court agreed he had grossly abused his advocacy privilege by making those unsubstantiated, damaging allegations. They even made a pointed comment about him exploiting the magistrate's likely unfamiliarity with the archaic maintenance charge. They said in such unusual circumstances, Clyne actually had a special duty to be especially cautious and careful, not to take advantage by making wild, unsupported claims.
Instead of being more careful, he was less careful.
Exactly. And they specifically highlighted, again, that he had ignored that direct and severe judicial warning given to him by Justice Manning back in 1957 about making unsupported allegations. The pattern was clear and damning.
Now, what about the argument Clyne's team tried to make? Taking comfort from the fact the magistrate had initially committed Mr. Mann for trial. Didn't that show there was some basis for the charges?
The High Court addressed that argument directly, and their response was absolutely cutting. Clyne's lawyers had indeed suggested the committal showed the charges weren't entirely baseless. The High Court's reply was dry, pointed, and utterly devastating. They said, "We are disposed to regard that fact, the fact Mann was committed, as rather damning than exculpatory."
Damning rather than exculpatory. What on earth did they mean by that? That sounds completely counterintuitive.
It does at first glance. But their reasoning was profound and quite chilling. They meant that the very fact his unethical tactics had actually worked, even just to the limited extent of getting Mann committed, didn't excuse Clyne at all. Instead, it proved precisely why decisive intervention by the higher courts was so desperately needed.
Because unethical tactics can succeed, at least temporarily.
Exactly. It showed, as they put it, that tactics that ignore elementary ethical standards may be successful up to a point. And that very fact, they concluded, so reinforces our view that only disbarment can meet such a case as the present. It was a stark observation. Unethical behavior can sometimes achieve short-term success, which is precisely why the courts must come down so hard to protect the integrity of the system and the public from such abuses.
That's a powerful point. And did the High Court also return to that fundamental standard required for practicing law?
Yes, they did. They reiterated the core standard, derived right back from the Charter of Justice that established the courts. A barrister must be a fit and proper person. They explicitly agreed with the Supreme Court that Clyne's actions, his repeated ethical breaches, his disregard for warnings and solemn undertakings, his fundamental lack of honesty and fairness collectively demonstrated he lacked the essential standard of common decency and common fairness required to hold the office of a barrister, an officer of the court.
So the final outcome was absolutely sealed by the highest court in Australia.
Yes. The High Court unanimously upheld the disbarment order. On that day, June 21st, 1960, as the sources state quite definitively, Reuben Peter Clyne's Australian legal career was effectively over. Done. Finished.
Okay, let's step back now. We've followed the whole dramatic story. Let's try to zoom out and really pull together the core ethical breaches that Clyne committed. Why is this case so important? Why does it remain such a vital lesson for understanding a barrister's role and responsibilities even today? What are the big takeaways?
Right. It's crucial to understand why Clyne became such a cornerstone case in Australian legal ethics. There are several critical reasons, several key lessons. First and foremost, it stands as a classic, almost textbook example of the abusive court process.
Abusive process.
Yeah.
What's the core principle there?
The fundamental idea is that legal proceedings, courts, lawsuits, prosecutions, they exist for genuine, legitimate reasons, to resolve real disputes based on facts and law, to enforce people's rights, to prosecute actual crimes where there's real evidence. They are absolutely not meant to be used as weapons, not as tools for intimidation, not as bargaining chips in unrelated fights, and definitely not as a way to achieve purely ulterior motives that have nothing to do with the proper administration of justice.
And Clyne's actions were a perfect example of violating that.
A perfect, blatant example. As both the Supreme Court and High Court found, those criminal maintenance prosecutions against Mr. Mann were admittedly devised as a means of intimidating that solicitor. They had no other object in view than the elimination of Mr. Mann from the Jacombe civil cases. That, the sources confirm, is a textbook example of an abusive process.
So the lesson for lawyers today.
It's crystal clear, especially for barristers who have that direct power to initiate and conduct court proceedings. Your duty to the court is paramount. It overrides almost everything else. And that duty strictly forbids you from using legal procedures for improper ends. If your client genuinely believes their opponent is acting improperly, or that a case against them is frivolous or vexatious, there are proper established ways to handle that within the system.
Like we discussed before, applying to stay the proceedings or making a professional conduct complaint?
Exactly. You must use those legitimate channels. You absolutely cannot engineer bogus cases or misuse genuine ones solely for an ulterior motive, like trying to scare off the opposing lawyer or gain leverage in a different dispute. That's a fundamental abuse.
Okay, that's abusive process. The second huge takeaway seems to be the powerful lesson on the misuse of advocacy privilege.
This is completely central to the Clyne case, yes. We talked about the absolute immunity barristers have for things said in court. It's essential for fearless advocacy, allowing them to represent clients vigorously without fear of being sued for defamation.
But it's not a blank check to say anything.
Absolutely not. It's a privilege granted for the public good, intricately tied to the proper administration of justice. It is not an unlimited license to say whatever hurtful, damaging thing you want about whomever you want, whenever you want in court.
And Clyne's conduct was a clear violation of that responsible use of privilege.
It was a gross abuse. He deliberately introduced damaging, irrelevant matter, those incredibly serious, reputation-destroying accusations of fraud, perjury, blackmail, into the committal hearing. And the killer point is, he did it knowing he could not back those claims up with any actual evidence. As the High Court summarized it, the privilege is grossly abused if counsel makes statements which may have ruinous consequences to the person attacked and which he cannot substantiate or justify by evidence.
He weaponized the shield.
He absolutely did. He took a protection meant for honest advocacy and deliberately used it as a sword to smear a colleague, knowing he was immune from being sued for the damage he caused.
So the enduring lesson here for advocates.
It's absolutely vital, and it's now a core principle embedded in legal ethics rules everywhere. Privilege comes with immense responsibility. You must never, ever make allegations of serious misconduct against anyone in court, whether it's a witness, the opposing party, another lawyer, anyone, unless you have reliable information to warrant the suggestion. and you must have a definite, genuine intention to actually present evidence to try and prove that allegation. To do otherwise, to just throw mud hoping some sticks, is a fundamental breach of your duty of honesty and candor to the court.
Right. The third big theme seems to be about the duty lawyers owe to each other, beyond just fighting for their own clients.
Yes, the issue of unfounded attacks on a fellow practitioner is really key here. Lawyers aren't just hired guns, they are also officers of the court. They are participants in a system that's meant to achieve justice. And part of that means they owe certain duties not just to their clients in the court, but also to the administration of justice itself. That includes maintaining a basic level of professional courtesy, fairness, and respect towards their opponents.
It sounds a bit idealistic, maybe. Does that collegiality really matter?
It really does. That basic professional respect helps the whole system function more smoothly and fairly. It maintains the integrity and public standing of the profession. Constant, baseless attacks between lawyers undermine everyone's trust in the system.
And Clyne's actions were the absolute antithesis of this.
Completely. His savage, baseless public attacks on Mr. Mann weren't just personally damaging to Mann, they tarnished the reputation of the entire profession. And that specific attempt to force Mann out of the case by threatening to drop the bogus criminal charges. The sources describe that as essentially extortionate, using his own client as an instrument of blackmail. This kind of conduct is just utterly incompatible with the standards expected of an honorable barrister.
So the lesson is about basic fairness and respect for colleagues.
Yes. Breaching that duty, especially when it's combined with breaching the duty of honesty to the court by making unfounded attacks, simply cannot be tolerated. The courts, often prompted by the professional bodies like the Bar Association, have a duty to step in to protect the public and maintain the integrity and honor of the profession. Trying to destroy a fellow lawyer without foundation, like Clyne did, has absolutely no place.
And the fact that Clyne had been warned before that he was a repeat offender, that was a major nail in his coffin, wasn't it?
Oh, absolutely. That element of breaching undertakings and repeat misconduct was hugely significant for both the Supreme Court and the High Court. Remember, the Supreme Court specifically noted he'd received that direct and severe judicial warning from Justice Manning back in '57 about making unsupported allegations.
And then he gave that formal promise, the undertaking.
Exactly. Just months later, he gave a solemn undertaking to the Supreme Court itself, promising to abide by professional standards, even assuring the court he understood his obligations. So his decision to then turn around and repeat and drastically escalate the very same type of misconduct in the Mann case, it just showed a profound lack of ethical self-awareness. It showed he hadn't learned from judicial correction, and it showed a blatant disregard for a formal promise made to the highest court in the state.
So ignoring warnings and breaking promises to the court is a big red flag in disciplinary cases.
A massive one. In professional discipline, a pattern of ignoring ethical standards or breaching formal undertakings given to a court is always seen as a very serious aggravating factor. It strongly suggests the person lacks the fundamental character and judgment required to practice law safely and ethically. It makes it highly likely they'll lose their right to practice, as happened so spectacularly to Clyne.
And all these different breaches, the abuse of process, the misuse of privilege, the unfounded attacks, the repeat offending, they all pointed to the ultimate question the courts had to answer, didn't they?
They did. All of Clyne's conduct, when you look at it cumulatively, led the courts to one inescapable conclusion. He no longer met that fundamental threshold requirement for practicing law. He was not a fit and proper person.
Why not? What specific qualities did they find lacking?
The courts found his actions demonstrated he lacked the essential standard of common decency and common fairness. He lacked the basic honesty required of someone holding the privileged position of an officer of the court, someone entrusted with the administration of justice.
And just to hammer home that point about why disbarment was seen as the necessary, unavoidable outcome.
It's really vital to keep remembering the court's reasoning here. They were crystal clear. Disbarment isn't primarily about punishing the lawyer. It's fundamentally about protecting the public, protecting clients, witnesses, the whole community from someone who has proven themselves unfit to be trusted with the immense power and responsibility that comes with being a lawyer.
And protecting the profession's integrity, too.
Yes, and protecting the integrity of the profession and the justice system itself. Ensuring that such gross abuses of privilege don't go unchecked, because if they did, they could erode public trust and even threaten the privileges themselves. The core message echoing down from Clyne is stark. If you grossly abuse your privilege, you will lose that privilege.
So what actually happened to Reuben Clyne after the High Court delivered that final fatal blow and his Australian legal career was definitively over? What was the aftermath for him?
Well, the case itself, as you can imagine, sent absolute shockwaves through the Australian legal community at the time. And it remains, even today, decades later, a truly stark cautionary tale. For Reuben Peter Clyne personally, the consequences were immediate and permanent in Australia. Once the High Court confirmed his disbarment, he was excluded from the Australian legal profession, for good.
Did he ever try to get back in? To be readmitted to the bar?
He did, yes. The sources note that over the following years, he made no fewer than 5 attempts, either to appeal the disbarment order somehow or to apply formally to be readmitted to the bar.
5 attempts. And what happened?
Each time the courts refused. They consistently found that he had not sufficiently demonstrated that he had regained the necessary moral character, the fitness and propriety required to be allowed back into the ranks of practicing barristers. The door remained firmly shut. He was never allowed to practice law in Australia again. He remained, as one commentator rather vividly put it, an outlaw in the eyes of the bar until his death in 1987.
That's quite a legacy. Or lack thereof.
It's a really powerful, almost tragic illustration of how hard-won a lawyer's professional reputation is, how easily it can be utterly destroyed by fundamental ethical failures, and then how incredibly difficult, bordering on impossible, it can be to ever restore that lost trust and standing.
Did he do anything else with his life?
Apparently, yes. The sources mentioned briefly that he lived a life outside the Australian bar doing things like writing, and reportedly even served for a short time as a magistrate in a foreign country. But the key point is he was permanently barred, permanently excluded from the profession he had once practiced in Australia.
And what about Mr. Mann, the solicitor who was the target of Clyne's whole campaign? What was the aftermath for him?
For Mr. Mann, the entire ordeal must have been incredibly traumatic, obviously, having your professional integrity savaged in public, facing criminal charges. But ultimately, the outcome was entirely vindicating for him.
How so?
His name and reputation were completely cleared. First, by the Attorney General's decision to drop the baseless criminal charges, and then definitively by the very strong findings of both the Supreme Court and the High Court, which stated clearly that he had done nothing wrong and that Clyne's accusations against him were baseless, improper, and disgraceful. He had withstood the attack. His professional standing was affirmed.
And he had support from colleagues.
Yes. The fact that senior, respected counsel like Mr. McIntosh QC stepped up to defend him publicly against Clyne's attack also underscored the profession's support for him against such tactics. And as we mentioned, he didn't just take it lying down either. He pursued his own legal action against Mr. Jacombe for malicious prosecution, seeking compensation for the harm Jacombe's scheme had caused him.
Okay, so beyond the personal stories of Clyne and Mann, what is the lasting legacy of this case, Clyne v. NSW Bar Association, for the legal profession as a whole? Why is it still talked about?
It became, and it absolutely remains, a foundational precedent in Australian legal ethics. You'll find it cited constantly in court judgments, in legal textbooks, in ethics seminars. It's a leading authority on several crucial points.
Like what specifically?
Primarily on a barrister's paramount duty to the court. The idea that your first duty isn't just to win for your client at all costs, but to uphold the integrity of the justice system itself. And crucially, it's a leading case on the limits of zealous advocacy. It draws a very clear line in the sand.
So it's a case that law students and aspiring barristers encounter pretty early on.
Oh, absolutely. It's pretty much required reading in legal ethics courses, especially for those intending to go to the bar. It's taught exactly as we discussed it, as a powerful, sobering example of what not to do.
A demonstration that your first duty isn't to the client's possibly crazy whims.
Exactly. It shows starkly that your first duty is to the administration of justice. If a client comes to you and suggests or demands conduct that is clearly improper, unethical, or an abuse of the court's process, like, say, trying to eliminate the opponent's lawyer through manufactured charges, the lawyer has an absolute ethical obligation to refuse. You must say no.
And Clyne's big mistake was going along with Jacombe's desperate plan.
That was his catastrophic failure. His decision to participate in and indeed orchestrate Mr. Jacombe's desperate, improper scheme cost him everything. The case also powerfully reinforces that treating your fellow lawyers with basic courtesy and fairness isn't just optional niceness. It's an actual ethical mandate, rooted in making the justice system work properly.
Have the principles from Clyne been written down anywhere, like in official rules?
Yes, absolutely. The core principles that were either established or strongly reinforced in the Clyne judgment are now explicitly spelled out in modern bar rules and legal profession conduct rules across Australia.
For example?
Well, there are now clear written rules that expressly prohibit lawyers from making allegations, especially serious ones like fraud or misconduct, unless they have a proper evidentiary basis for doing so. There are rules against using court proceedings for an improper purpose, like harassing someone or gaining a collateral advantage. Rules against misleading the court, rules requiring courtesy to opponents. What Clyne did would clearly violate multiple written rules today, on top of breaching those timeless unwritten standards of honesty, integrity, and professional responsibility that the Clyne case so vividly brought to life.
The case also seems like a strong example of the legal profession policing itself, doesn't it?
It really does. Clyne showed the system working in a way. It demonstrated that when an advocate grossly abuses the system and their privileges, the courts themselves, often prompted to action by the professional bodies like the Bar Association, will step in decisively to police that misconduct. This internal accountability, this self-regulation, is absolutely vital for maintaining public trust in the whole justice system.
And the High Court was clear about why they had to act.
Very clear. They stated that removing Clyne was necessary to protect litigants, witnesses, and the public generally, and also to preserve the honor and integrity of the bar itself. It hammered home that the privilege of being able to practice law isn't a right, it's conditional. It requires continuous adherence to the very highest ethical standards.
It's fascinating how, even though the original charge Clyne used, that archaic maintenance thing, is basically irrelevant now, the core ethical lessons from the case feel incredibly current and timeless.
They absolutely are. Honesty with the court, not abusing legal processes as weapons,
right,
showing basic respect for colleagues, even when you're fighting hard for your client. These are just fundamental, enduring pillars of ethical legal practice. It doesn't matter what year it is.
It was mentioned that Clyne seemed to lack ethical self-awareness.
Yes, the sources noted he was apparently intellectually brilliant, maybe even a brave advocate in some ways. But he seemed to have this stubborn refusal to realize what he was doing and how others perceived it. That lack of essential ethical self-awareness was perhaps his fatal flaw. The case stands as this permanent, stark reminder that no amount of brilliance, no amount of courtroom bravado, no amount of pressure from a desperate client can ever justify abandoning your fundamental ethical duties as a lawyer.
Those dramatic events, the Sydney courtroom ambush, the high-stakes disciplinary hearings, the final judgment from the High Court, it really does have the pulse of a legal thriller.
It absolutely does. And it's been aptly called, I think, the barrister who went too far. It had all those captivating elements: the desperate client, the scheming, the innocent lawyer targeted, the public courtroom showdown, and then the ultimate definitive reckoning by the highest courts in the land.
But its real value isn't just the drama.
No, its enduring value, its real legacy lies beyond the drama itself. It lies in the powerful, enduring cautionary tale it represents for every single person who practices law or aspires to. It serves as this constant, vivid reminder that the courtroom is supposed to be a place for seeking truth and resolving disputes based on established rules and principles of fairness. It is not a battleground for personal vendettas. It's not a stage for launching baseless attacks under the cloak of privilege.
Privilege demands responsibility.
That's the crux of it. Abuse that privilege, and you risk absolutely everything. Reuben Clyne's fate stands as permanent, stark proof of that inescapable truth. Ultimately, you could say justice was served in the Clyne case not just for Mr. Mann, whose name was cleared, but for the integrity and standards of the legal profession itself.
So if we had to boil it all down, distill the absolute core takeaway from our deep dive into the Clyne case today.
I think the case of Clyne v. NSW Bar Association is just this incredibly powerful, incredibly dramatic reminder that a barrister's conduct, a lawyer's conduct, must always prioritize upholding the integrity of the justice system itself. That duty comes even above, and maybe especially when tested by, the client's desperate desires or demands that might push toward unethical behavior, ethical boundaries in the practice of law. They aren't just suggestions or guidelines. They are fundamental, non-negotiable requirements of the profession. Cross them at your peril.
That story definitely leaves you with a lot to think about, doesn't it? I mean, how do we ensure that the absolutely crucial need for lawyers to advocate zealously, fearlessly for their clients never crosses that fundamental line, the line into abusing the very system that's designed to deliver justice in the first place.
It's a constant tension, isn't it?
Yeah. And what is that responsibility of wielding legal privilege, that incredible power, that immunity to speak freely in court? What does that truly mean in today's world? A world where accusations can spread like wildfire online and reputations can be shattered in an instant?
The stakes feel even higher now, perhaps.
Maybe. And how does that public interest, the need to maintain the absolute highest professional standards for lawyers to protect all of us, how does that really balance against a client's fundamental right to get robust, effective, maybe even aggressive legal representation when they need it most?
Those are exactly the profound, difficult questions that a case like Clyne forces us all to confront. They reflect those timeless principles, those tensions that should govern everyone who steps into a courtroom, everyone involved in the justice system.
Definitely food for thought.